2.
Michael Turris, Director, Department of Planning and Zoning.
Phil Weckeser, brand new to the Planning Commission.
Brad Ormsby, Planning and Zoning. John Studer, Planning and Zoning.
John Casoni, new to planning and zoning.
All you guys, thank you so much for having your hands on that.
Planning and zoning, about 6 years.
Mike Kavanaugh, Planning and Zoning.
Except for planning and zoning and the CDA.
Joe Claremont, District 5. Joe Postman, District 1. Steve Warfield, District 7. Joe Boston County Administrator. Okay, we're gonna turn it over to Jeff.
Forgive me if I eat pizza and try to talk at the same time. Appreciate everybody being here today. This is a joint work session between the Board of Commissioners and the Planning Commission. These 3 topics we'll try to tackle today, if time permits here. This is talking about renewable energy, kind of our pathway forward. Right now, we're under a moratorium in the community. We have an option right now to review the options that the county has to move forward. We'll go over that here shortly. Number 2, hopefully we'll have time, is to talk a little bit about the industrial zoning districts. The Planning Commission just had a recommendation for amendment change in one of the provisions. A couple items were removed under housing and a few other daycare was removed. We have a few minutes to talk about that as a kind of joint work board here. We can go over some of the quotes the board has either for additional review or to the Board of Commissioners. And 3 would be hopefully talk generally about special use standards. Most communities have objective standards that are specific to measurements, and we do have some standards that are subjective. There's not necessarily a problem with subjective standards, just usually when they're used, you have to be careful when you exercise those. Most provisions for special use are typically objective or can be measured in some degree. So we'll have a conversation with that. So jumping back into the first topic is discussion under pathway moving forward here for renewable energies. As we know, Public Act 233 kind of changed the platform for communities in Michigan. Communities in Michigan typically don't like when state regulations for managing land use. So all our major associations, Madison County, MAC, MPA, or was the PML, all gave their concerns to the legislature with that. The act was passed, and that's the standard here in Michigan now moving forward. So as we look through the pages here, we have some options. If we turn to page 1, we see option 1 is adopt a compatible renewable energies ordinance, or a CREO. The option 2 is adopt a workable local ordinance. And option 3 is not to have an ordinance, but to have all applications go to PSC. So hopefully everyone's got a little bit of time to review the benefits and the considerations under those. If you like, I can start to walk through those. Mike, anytime you want to jump in, you can do that also. So, as an overview of the compatible renewable energy ordinance, basically follows the guidelines of PA 233. So you're setting your standards to match what the legislation is. So in that case, you can see under the benefits, it preserves local review authority. So it gives us a pathway to actually review that and have a conversation with the developer, but it doesn't in the framework of what PA 233 allows. Provides regulatory certainty because it's based on 233 and maintains a local participation. Considerations, limited ability to impose additional restrictions, potential public concerns. You can read that here, and you do have public here, the board's discretion. You can look at those comments there. Residents may review a CREO as a limited local discretion, reducing the county's ability to restrict illegal energy developments. Just before we move to option 2 there, is there any questions, or do you want to have conversations around that particular option?
I would just add, Jeff, that all of you are probably aware that we had a CREO that was repealed back in February. And the table on page 4 of the handout, I think, is a good comparative summary. In fact, that's what the table inspired. That shows the pros and cons of each option.
If I might add a couple of comments here. Well, I have not question, comments. For those of you that don't have the background, I can give you the background on where we got to where we are today. Back in whatever year it was, second year or two ago, 2018.
Pardon me for speaking with my mouth full. It was 2017, Jeff.
2017. Back in 2017, the Planning Commission got a directive from you, the Board of Commissioners, that we needed a regulation governing solar ordinance. At that point in time, we didn't have a planning director. We didn't really have any staff other than the administrative assistant, Debbie Tomlinson, and a planner who was retiring. So I basically put together the regulation we originally had on solar. We had a number of meetings of the Planning Commission where we thrashed it around. We had several public hearings which were contentious, but we finally came to a resolution on ironing out changes that were more or less acceptable to the general public. And it was turned over to the Board of Commissioners and was passed. Subsequently, PA 333 came in, which kind of threw things into a tailspin. As Mr. Lawson has pointed out, one of the options was a CREO. Our legal counsel recommended going with the CREO. I might point out that that was not the legal counsel we presently have. It's the prior legal counsel. I didn't agree with the CREO then, and I don't agree with the CREO now. I don't think it gives us any option for the local populace to have any real input on controlling what a solar farm turns out to be or where it will be. So, at the advice of council, we passed that you approved an amendment to go with the CREO. Luckily, I advised that we leave our regulation in place, so we in fact had two regulations. One was a CREO and one was our original solar ordinance. The company that was coming in at that point in time, which generated the request from the Board of Commissioners and the Planning Commission to write a regulation, came in and they wanted to put in a solar farm. That became a critical, time-sensitive reason for coming up with the regulation, which we came up with. Well, subsequently, it turned out that wasn't really much of a time-critical thing because it went on for several years after the regulation was passed, and they never did get the thing going, which resulted in the regulation, the SUP that we did pass and that was approved expired. It was was an extension, and the second extension, and that expired. So it went on over a period of several years, and the project never was initiated, so it expired. Well, now we're at the point where we're getting back in, but we've got a moratorium. But that's where we stand now. They came back in for a new SUP, which was approved, and was subsequently overturned by the court. And the court based it on the fact that the current legal counsel approved the defense of the SUP that we approved, based basically on the sole part of the regulation pertaining to the CREO. The judge said, it isn't just the CREO, you've got the rest of the regulation, and you didn't address that. Well, as some of you know, I don't always agree with legal counsel. And I had recommended, as a matter of fact, Mike and I spent several days working on the justification for the entire thing in the first place. And we had it justified not only under the CREO, but under the original regulation, which the applicant voluntarily proposed to comply with in almost all cases. A judge looked at it and said, you didn't cover any of the rest of the original regulation, it's deficient, and he overturned it. Now, I don't agree with the judge's decision. It should have been remanded back to the Planning Commission if he felt that part of the regulation wasn't addressed, because we had it all compiled. All the material was there. But I personally think that we should have our own ordinance in compliance with what the people of this county feel is necessary in an ordinance for a solar farm in this county. Whatever it may be, whatever those criteria are, we should have it in our regulation. That's what we should be using. I don't think we should get into a CREO. I don't think we should have to worry about it going to the state. The state, I don't think, is going to act in any haste. And what they come up with as far as the criteria they're using, we still don't know. They've got a number of applications before them, and they still haven't acted on it. We don't know what their criteria are going to be. They don't have a regulation on it. We can't find out what it is. I think we should stick with our own regulation. If you're not happy with the regulation we have, we can modify that. But a CREO, I don't see the justification for it, and I don't think there's any protection for the county under either the CREO or going to the state, letting the state in. That's my analysis and my history of it.
Thank you, Jeff. Anybody want to talk about it?
May I ask a couple questions, please?
Sure.
I'm new to this organization, obviously, and our board has had quite a few discussions on this subject, most of which I listened and kind of digest what is shared with me. But there are a couple concerns that pop up based on our discussions. Number one, we can have an entity come to us and bring a project and go through all of the steps, and we build a relationship with that individual or that entity, only to find out once they've completed that process, they can sell that to another entity of which we have established no relationship whatsoever. I have a concern about that. Because if somebody's going to come into our county and take on a project like that, they have to understand us, and we have to understand them. And that is relationship building. That's trust building. Only to find that there's an out where they can do all this legwork and then turn around and market that to a highest bidder. Again, of which we have no relationship, very little knowledge of them at all. And then what is our position if that occurs? That's number one. Number two, I'd like to know how many solar farms sit on state land. Does anyone have any information on that? That is, in our discussion, that provided a big question mark for me. If the state is pushing green energy, and they have a massive amount of land, and they're in control of the permitting process, why is it that there is no solar farm on state land? We have a pretty good idea why. Because the risk to that land over an extended period of time. And also, when that project goes through its useful life span, whose responsibility is to take that out and make that land, take it back to the way it once was? Are you aware of whose responsibility that is? It's the landowner. It could be the farmer who didn't know anything about the end process of this whole project that allowed the leasing or selling of his or her land to instill something like this, only to have a major ground soil type issue or something at the end of this project that either they have to take care of or their heirs. But it says a red flag to me when I look at all the land around this area that is owned by the state. You know, this whole corridor of Michigan up here has some of the largest parcels of state land, but not one existing solar farm. They'll log out all the trees that they can. They're clearing the land, but they're not putting up one solar farm. That concerns me. It
Mr.
should
Chair.
concern all of us.
Mr. Chair, Zoni, as far as I know, from my quick and dirty search here, there are currently only 2 active state land leases inked with developers for utility scale solar on DNR land in the state of Michigan. Even though there are dozens of commercial or utility scale solar farms in the state.
To answer your question, it's the Natural Resources Trust Fund. Any land that's managed by or bought by the Natural Resources Trust Fund cannot be developed in any way. And that's the reason we don't have on a lot of the state-owned lands. As far as the cleanup goes, to answer your question, they have to provide bonding for the cleanup. So it's not at the expense, a lot of times it lays on the landowner, but it's not at the expense of the landowner. The solar companies themselves have to provide bonding, and that bonding has to be renewed every, I think it's 5 years.
5 years under our regulation.
Has to be renewed every 5 years and updated. And if the estimated cost of the cleanup goes up, that bonding has to go up to so that's.
Well, that wasn't discussed in our conversation.
Yeah.
But I'm
Both
glad we're
proposals
discussing
that
it.
have come before us had remediation clauses where bonding was required. Engineers had to review the appropriateness of the dollar amounts, and if they proved to be inadequate, in a professional's opinion, then the contract, or that element of the contract was to be renegotiated. So putting it back the way it was is part of the program by definition. But you're right, some of it does fall to the landowner at the end of the day, but again, not financial.
And that, what you pointed out, Mr. Delaney, that's articulated in our zoning ordinance. Those are requirements for submittal and review of a utility scale solar project. We call it level 3 solar energy system for the ordinance.
But let me check that. We're under moratorium.
Right.
So what our mission here today is get the pathway.
Right.
When we set this pathway, we set the regulations, which means that an ordinance will be drafted, redrafted, and brought back through the whole process.
Well, these are just concerns that I had, and I want to share them with you. As we craft ongoing future legislation, things that we should be cognizant of to protect our citizens and our land?
On your first question there, for all land use, under the state of Michigan, planning enabling legislation allows communities to establish planning and zoning based on master plan. So when an applicant submits, whether it's a rezoning, special use permit, or any other type of application, we have to process that under due process, regardless of who they are, regardless of who they'll sell to in the future. We have to review their permits based on what our ordinance permits. So I understand the working with, in this case, with the developer, but the planning commission should expect on any type of application that that can be sold. And that's not a provision that we can place under regulation, under state law, any kind of conditions on what they can do there, who they are, or anything else at the end of the day. So we need to have that expectation, whether we're talking about renewable energy or any type of development that says we can sell the property, and we may or may not be working with the same developer. It could be 1 year, it could be 50 years, but under state law, that's not a provision to review under planning and zoning under due process. So we have to take applications and put them through our process and make the decisions based on what the ordinance permits us to do. And you can't do regulations related to where a company is located, anything to do with their background, any financial capabilities, or anything else that has to be based on the ordinance.
Right, as I had mentioned on several occasions, recent planning commission meetings, just to echo what Mr. Lawson said, we have to be cautious about attaching conditions of approval that aren't reflected in the zoning ordinance, and be cautious about attaching conditions that really have no relationship to land use, what we're collectively charged with. So again, as Mr. Lawson pointed out, we don't have any oversight authority over the future sale of a project, for example. So we will certainly have these discussions, these deeper dives, I'm sure, once we decide. I think we need to focus on the pathway moving forward. And once we have that established, then these discussions will certainly follow.
Thank you.
And the solar developments or whatever, no different than any other special use, it goes with the land, and whoever owns the land has the right to maintain that use as long as they continue it.
That is correct.
One is, I would agree with Chuck. I'd like to see us go with a workable local ordinance, in the fact that there's a little bit of movement there, and obviously, as we've seen with Samir and the company that he represents, they would rather work with the county rather than go to the MPSC. They agreed to some things that typically, if they went through the MPSC, it saves them 10 miles of berming that they wouldn't have to do, yet they came to the county and wanted to work with the county. So they're okay with added expenses, and most of these entities or developers are. They'd rather work with the county because it's a lot faster process. That being said, I understand and wholeheartedly get the fact that government works at a snail's pace.